Come on in, come on in. Hello, hello. What's up, everybody? Hold on one second. I am trying to, hi, everyone, get my life together here. And today we are going to be talking about 10 mistakes to avoid in your child custody case. So if that's some info that you need, go ahead and jump in here. For those of you who are tuning in on Instagram, I went live on the wrong channel. So I'm supposed to be live on my Family Court Academy page. So if you are interested in this live, which is talking about 10 mistakes to avoid in your family court case, I'm going to click out of here. So join me over on Family Court Academy now. And for those of you who are on Facebook, welcome, welcome. If you're on YouTube, welcome. Thank you for tuning in. I am trying to get my Instagram live together. So bear with me for 1 second. If you are here to talk about 10 mistakes you can avoid in your family court case, you are in the right place. If you're not, please feel free to share this live with someone who can use this information. So I'm going to give everyone a couple of minutes to get on, and I'm going to pull up my comments. So thank you guys for jumping in here. If you're tuning in live on Facebook, Instagram, YouTube, I have all three streaming at the same time. So thank you guys for tuning in. Today we are talking about 10 mistakes to avoid in your child custody case. So go ahead, click like, click share. If you know somebody who needs to be here, go ahead and share. I'm just dropping some gems today. I'll be answering questions at the end, and we'll go from there. If you have any questions, feel free to use the comment section. I'll be checking the comments on my Instagram as well as on Facebook and YouTube. So again, thank you guys for tuning in, and I'm going to just go ahead and get started. Hello, hello, everyone. For the final time, I'm Merissa V. Grayson. I am a child custody and family law attorney, mediator, co-parent coach. I have represented fathers, mothers, children in family court cases for 10 years. And I am here today to talk about the different mistakes that I would love for everybody to avoid in their family court case. I see the same mistakes over and over and over again, and I legit just want y'all to win. So for those of you who have never met me or who are new around here, welcome. Thanks for joining me. I am the founder of Family Court Academy, which is a online platform where I teach parents how to win inside and outside of the courtroom. Through that platform, I also have a program called Child Custody Masterclass, where I teach people how to represent themselves without a lawyer, but like a lawyer. So that program is currently closed, but we will be relaunching within the next couple of weeks. We're just shifting some stuff around. So if you're interested in that, if you need some help with your child custody cases, I would love for you to join Family Court Academy and Child Custody Masterclass. Thank you all for being here. Again, please share this video if you know anyone who can use the information. And we're talking about, and going to jump right into 10 mistakes to avoid in your child custody case. Normally I would share my screen and have a PowerPoint. Today we just chilling, regular, informal live. I'll be answering questions at the end, maybe even during. So if you have any questions, feel free to drop them in the comment section, and let's get started. So for those of you, again, who have never met me, my name is Merissa V. Grayson. I'm an attorney primarily based in California. I have amazing attorneys in my network all over the place. So if you're looking for a family law attorney for a consultation or for representation, feel free to hit me up. I'll connect you with somebody. I am known as America's Blended Family Expert, a title that I did not ask for. I personally went through a child custody battle with my husband long time ago now. It was back in 2009. And because of the struggles during that battle, the confusion, the frustration, the anger, the everything, I decided that I was going to create a way for clients to work with me, not only in my family law practice, but also in my co-parenting coach practice, as well as my mediation program, where I teach parents how to learn how to co-parent, how to represent themselves in court, as I mentioned before. And just overall, I just want people to be able to navigate the family court system, whether they have a lawyer or not, and know what they're doing and actually have a chance at achieving the results it is that they're seeking. So I teach parents how to establish their rights. I've been known as a father's rights attorney. I also have some super dope mom clients. I also teach parents how to gain certainty and consistency for their children. If you don't have any custody orders in place and you want custody and visitation orders in place, I work with parents to help them do that. I teach parents how to protect themselves and also how to use the legal remedies that are available to them. So why are we here? We're here today, and I chose this topic today because I keep, as mentioned before, I see the same mistakes over and over and over in family court. Pre-pandemic, I used to have to sit in the actual courtroom and observe other cases that were being called before mine. And I would literally cringe just seeing the mistakes that were being made. And it really was just, really disappointing and saddened me that so many people just don't really know how the family court system works, how to navigate it. A lot of people are intimidated by it, rightfully so, right? And so I just decided that I wanted to do a talk on some of the mistakes that you can avoid. So let's just get right to it. So mistake number one, one of the biggest mistakes, and this is not in any particular order, this is just the things that I jot down that I see on a regular, but one of the biggest mistakes that I see consistently is that people mistake number one is taking advice from non-lawyer friends, family members, and people that you know. And I think that this is a really big mistake because a lot of times we think that, yeah, my friend went through a divorce or a child custody case or, a child support battle or whatever the case was, and this is what they did. So let me just copy what they did and it's going to work for me too. And the reality is that oftentimes cases don't work like that, right? Unless you have the exact same fact pattern, the exact same judge, exact same courtroom, and, the exact same circumstances, your situation may not be the same as the next person. So while it's great that you have someone that you know that can give you some insight into the family court system and how it works, the reality is it's really, really important and it's smart for you to seek counsel from someone who is experienced in navigating the family court system, specifically in your area, specifically a lawyer in your area, right? So if you are going through a court battle, of course, if you need to talk to your friends, talk to your family members, do that. But ultimately, you need to get professional advice rather than taking the advice from someone who may have personal experience but doesn't have any professional experience and may unintentionally lead you down a path that you don't want to go down, right? So, for example, an example I'll use is contempt actions. A lot of people, when someone is violating a court order, they are quick to tell someone, you should just file a contempt motion against the parent that's violating, right? And what people often don't realize is that when you file a contempt motion or action, because it's semi-criminal, right, that the person who is being accused of contempt now has the right to remain silent. And because of that, in most states, they'll be appointed an attorney, right? And they don't have to testify about what's going on in your case. So if you need some immediate orders made, then the court can continue your case over and over and over until the contempt action is resolved, because that person doesn't have to answer any questions about why they aren't following the order. So there are different ways to actually enforce your orders. But people are always, just really quick to tell people, oh, you need to file for contempt. So that's just one example of the things that people, do. Your friends and your family, they have your best interest at heart, hopefully. Sometimes they don't. Sometimes they just want to add fuel to the fire, right? But their intentions and reality might not be in alignment. So it's just really smart, again, to make sure that you discuss your case, your circumstances, and everything with someone who is professional and knows what they're doing, specifically in the legal realm. All right, mistake number 2 to avoid: hiring a lawyer who is not well versed in family law. I know that you have an auntie, a cousin, a friend who does criminal law or personal injury or civil litigation, which is a little similar, but not. The reality is family law is a very nuanced, complex area of law. There are attorneys who have been practicing for years and years and years who still struggle with family codes, family laws, knowing the procedures, and figuring out certain aspects of family law, because the laws change, the rules change, and things don't necessarily always go as you anticipate, right? Just like with criminal law or any other area of law. When we're talking about family law, though, right, we're talking about you're going in front of a judge who is going to make a decision that's going to potentially impact your life, your freedom, your children, most importantly, your finances, your assets. And it's really important that whoever you hire to represent you in your family law case is well versed in family law, because one, they might advise you based on what they think that you should do, but what's not in alignment with the law, right? Like, even having been practicing for 10 years, there are still some issues that come up that I have to go back and be like, okay, let me make sure nothing has changed, make sure I'm up to speed, make sure I have the best strategy. And that's with me knowing the different difficulties that come up and the complexities that are associated with family law. So just make sure you need to hire somebody. If you're going to hire a lawyer, right, hire somebody who knows what they're doing and is not just taking your money just because they want to have a case and they don't know what to do with it. So that's mistake number 2. Mistake number 3, not being prepared and using the "I'm not a lawyer" excuse. And this really it goes out to everybody who wants to represent or has to represent, whichever it is, themselves in court. So I have a YouTube channel. For those of you who don't know, follow me, Merissa V. Grayson. But on that channel, I talk about this a lot because I do videos for people who represent themselves in court. And one of the biggest things that people don't understand, or, one of the misconceptions, is if you don't have a lawyer, the judge will give you a little bit of leeway. You don't have to follow every rule, every procedure, every whatever, right? Reality is that's not accurate. And if you're representing yourself, you are still going to be expected to follow the rules, the procedures, and know the law that is related to your case and the issues of your case, right? So you can't show up not prepared. You can't forget to file a document. You can't not file a response and say, oh, I didn't know that I had to file a response. You should have known, right? So that goes back to, even if you're not going to hire a lawyer to represent you, I always tell people, hire somebody who can give you advice and guide you, a step-by-step system on what to do with your case, how to handle your case, and the way to move your case forward. So at least you know the rules, the procedures, and how to look up the laws and different things like that. For those of you who are representing yourselves in court, I know that we're in the middle of a pandemic, so this might be a little bit more difficult. But if the hearings are broadcast online in your area, or if the courtrooms are still open and they're allowing spectators to come in, it's always a good idea to jump in there and go to the courtroom and sit and watch the cases that are not considered confidential, right? You sit in there, you get to see how the judge moves, how they think, what annoys them, right? What their processes are, how their courtroom works. And I talk about this a lot in Family Court Academy, but this is just, a small thing that you can do to make sure that you're prepared, so that you know what little things trigger a judge. If I didn't file something on time, what are they likely to do? So be prepared, do your research, right? If you don't know how to find the laws in your state, Google child custody laws in whatever state you're in. Google child visitation in whatever the state is. There is findlaw.com, and that will give you pretty much, it's like a search engine related to the law. You can find the laws in the family codes and the codes of civil procedure there. There are so many different places that you can find the laws, but you got to do some research and look it up. There are tons of blogs out there where lawyers actually provide information, and they do in-depth articles on various issues. So, for example, if you're talking about domestic violence and child custody, if those are an issue in your case, Google domestic violence and child custody in Atlanta, Georgia, if that's your area, right? You'll find articles, and in those articles, a lot of times they reference the laws and the rules that are related to your area. So, like I said, even if you don't have a lawyer, I just want you to show up as prepared as possible. You're not going to do it perfect. That's not going to be expected, but you at least need to do it as best as possible. Don't walk in there talking about, I'm not a lawyer, so I didn't know that I had to file this document. It's findlaw.com, FIND, like find, I'm looking for something. I had to find it like that. Findlaw.com. And I will post the links in the comment section that I mentioned when I'm done. So, all right, mistake number 4. If you guys have any questions, drop them in the comments. I am happy to answer them for you. Mistake number 4, not following your existing court orders. This is one of the biggest mistakes that people make. It is also how I win a lot of my cases, because for whatever reason, people think that following their court orders is not mandatory. So here's the thing. Court orders are put in place for a reason. You have some judges that are kind of lenient. They might give you a little tap on the wrist if you don't follow completely. But then you have other judges that are like, I gave you an order. You're expected to follow the order, so you didn't, so here's your penalty, right? You want to make sure that you are always the parent who is following the court orders. I don't care if they violated the orders last week. I don't care if they told you they're not going to do X, Y, and Z this week. And this is with the exception of an emergency, of course, something out of your control, or something that is related to your child genuinely being at risk. And I don't mean you mad at the dad or the mom, so you're not going to drop the kid off. That's not being at risk. So follow your court orders. If there is a problem with your orders, if the orders need to be modified, if you need to deviate for the orders, then you file whatever motion is required in your state and you request that the orders be modified. If there's an emergency situation, right, and you need immediate modification of the order. So for example, your child comes home and they say that, let me think of something. Somebody abused them. And I mean legitimately abused them. Not they got mad and put on punishment for staying up too late and doing something they ain't had no business, and now they're mad at the other parent. I mean, they legitimately were abused or something of that nature, something that put them in harm's way, true harm's way. And I keep saying that because false allegations is really a thing. I'm not going to jump into that right now. Whole nother video, whole nother day. But there's a legitimate reason. Something happened at the other parent's house, right? Your kid comes home and you believe that it would be dangerous to send them back. Most states have some type of emergency proceeding that will allow you to file a request to immediately modify or terminate the orders based on whatever those circumstances are. In California, we call that an ex parte motion. In some other states, they call it various other things. But Google emergency orders in whatever your state is. Emergency child custody orders. Ex parte child custody orders. And ex parte is spelled E-X-P-A-R-T-E. 2 separate words. Ex parte. So anyways, so if you need to violate the orders, you need to file that motion, and those are usually heard within 24 hours, 48 hours. Some states or cities or counties, it might be a couple of days. But you violating the order for 3 days is much different than you violating the order for 3 months until it's time to go to court, right? So if you don't follow your orders, you may be penalized for that, whether that be in contempt, held in contempt, whether that be fined or sanctioned by the court, or in a lot of cases, modification of custody, or full-blown, they will snatch your custody away if you've done it too many times and the judge is over you and your foolishness, right? So always protect yourself, because you just don't want to put yourself in a position where you end up losing custody of your kid because you violated the order for whatever your reason is, right? So that's mistake number 4. I see questions coming in through the Facebook YouTube feed. I did not forget you guys. I am going to answer them. If anybody else has any more questions, make sure you keep dropping them. Everybody click like and share if you know anybody who could use this information. Mistake number 5 to avoid: angry or emotional text messages, emails, social media posts, right? Your behavior on social media is one of my top methods of finding evidence. I'll say that again. Watch how you're talking on social media, what types of messages you're sending, and what you're posting about your case on social media. My clients know I ain't having it. We don't post on social media about the case, right? Because it causes drama. 1, it makes things a lot more complicated, and you don't want to give all your business away, right? You don't need everybody all up in your business. So just be very, very careful of what you're posting on social media. If you're supposed to have your kid and you say that the kid is with you, but you post on Facebook that you're at the club, right? Who got the baby? All of these things, are things that are going to be important in the long run. So just make sure that you communicate in a way, specifically when you're communicating with your ex. Make sure you're respectful. Make sure that you ain't cursing them out, acting a fool in your messages, lying in particular also, right? Because that always comes back to you. And just be aware. And that includes your DMs, right? I know that you think that your direct messages are private. They're not. They might be for a moment, but a good attorney can get to them, right? So just be very careful of the things that you're saying. Don't be threatening the other party. That could always get you in trouble. Threatening to keep your kid away. That's another thing that people do on social media or in DMs or texts that always comes back to bite you and haunt you, especially if you follow through with that. Those types of things, keep it off of social media. Some things are not meant to be social. All right. Number 6, boop. Not keeping record of all communication and contacts. This should be a given, right? But I tell my clients, keep records of everything. I mean, how often your visits are, if you follow through with the visits, how often you get to speak to your child on the phone, if there has been any interference in your custodial time or your phone time. If your child comes back sick, if they come back harmed, whatever the case is, you need to keep a record of everything. When you take the child to the doctor, if there was a no-show, whatever it is, keep accurate records, because you or your attorney may need to be able to provide that information for the court. And if you don't have records, it's really difficult to try to go back and figure out, well, did I get to visit that day, or did I get the phone call? Because I can't remember if that's the day that he hung up in my face and wouldn't let me talk to the kid. Keep records. And for those of you who are on my email list, you probably already have. I have a co-parenting journal. If you don't have it, I can get it to everyone who's on here. It's a co-parenting journal that will allow you the space to communicate or to jot down and keep track of the things in your co-parenting relationship. So these are things that you should also, like I said, be aware of. Just keep track of everything. If I'm your attorney in particular, for example, when you come on as a client, right, and I need all of the information about all of the visits, which ones went forward, which ones were violated, whatever your issues are, it's really nice when I have a client that sends me a Word document that's bulleted with every single court violation, with every single visit that happened, with all of the issues summarized so that we can make an argument accordingly. So just make sure, again, you're keeping records. I know I sound like a broken record, but it's really, really important. Number 7, signing bad agreements without question. This is something that a lot of people do because they are so eager to try to settle cases. And oftentimes, if you get the wrong attorney, they will convince you to sign an agreement that you know ain't gonna work for your family, or you know is not gonna work for your kid, or that you just don't fully understand, right? So if you're represented, one, your attorney should be explaining every line of your agreement to you. So make sure that you ask those questions. That's why you have a lawyer. That's why you hired them. You need to make sure that you're clear. I have a lot of people call me and say, hey, I got this agreement. My attorney's telling me to sign it, and I don't really know if I should do that. Problem number one, you don't trust your attorney. You need another lawyer, right? Number two, though, you need to make sure that you're reading your agreements and you understand what's in there, because when you sign these agreements and then you don't follow them, or there's a problem with them, it's a lot harder to undo that stuff, right? So also understanding the gravity of what you're signing. For example, in a lot of cases, one parent will accuse the other parent of alcohol abuse, drug abuse, whatever. And a lot of times, for the sake of just being able to save their time with their kid, or to do, to appease the other parent, they'll agree to, for example, y'all hear the helicopter, plane, whatever that is. Sorry about that. Anyway, they'll agree to drug tests, random drug tests, right? I've had several clients who have agreed or been pressured to agree to random drug tests just so that they can see their kids, right? So then we have to go back to court to try to modify the order, because one parent is always requesting drug tests for no reason, just to make things difficult. And they're going to get drug tests every week. They're passing every single one. But because you agreed to do that, right, now you're stuck for 8 months doing drug tests unnecessarily, coming out of the pocket with drug tests, not realizing how much that's putting on you. And then you show up in court, right? And the judge is like, well, if there was no drug problem, why did we agree to a drug test, right? There might really be a drug thing going on, and that might cause the court to question things as well. So just be careful what you agree to. And I'm not saying that I don't want you to compromise, because compromise, you guys know I'm all about trying to make it work and doing what's best for your kids, first and foremost. Compromising is good. Reaching an agreement, I settle a lot of my cases. We're able to resolve things without having to go to trial, without having to go to court. Some cases we have to, most we don't, right? But I always encourage you to, if you're reaching an agreement, it's never going to be 100% what you want or what the other parent wants. But you don't want to agree to stuff that's going to put you in a position that is going to make it more difficult for you moving forward to modify. So seek counsel if you can, so that you know the severity of what you're agreeing to before you agree to it. All right. Mistake number 8, disparaging the other parent, talking mess about the other parent, posting negative things about the other parent on the internet, or talking negatively about the other parent in front of your kids, especially, right? Your child's other parent may be extremely whack. That's the reality, right? They may be. There's a lawyer that I work with. He always says, you picked them, right? You knew who you were dealing with. It is what it is, right? However, regardless of whatever your dynamic is with them, that's your dynamic with the other parent. That should not be your child's dynamic with the other parent. They should not know. I have some 3-year-olds that come in and they know what the term deadbeat means. A 3-year-old should not know that. And I know that they learned that from one parent, right? There are some things that just don't need to be said. You don't need to talk negatively about the child's other parent in their presence, within their hearing distance. When you do that, you are damaging your children psychologically. I know you don't think it's a big deal that you called their father sorry, or whack, or a deadbeat, or that you called their mom crazy, right? But these are things that, if they are true, your children will learn on their own. You ain't got to tell them. They'll figure it out on their own as time goes by. What you want to do is make sure that every word that you have spoken about their parent, right? Because technically the child is half of you, half of them. I say this all the time. If you hate their other parent, to them, you hate half of them. You hate part of them. And that's how children perceive that. How do I know that? Because I represent kids. And almost always when kids hear their other parent speaking this way about the other parent, they feel like it's something they did wrong. It's something they could have done differently, or that they're the problem and they're the reason that their parents don't get along. Like, don't be like that. Keep it positive. You need to vent to your friends or your family members about how this person is so horrible and frustrated and angering you and all of that. Do that in your own time, but don't do that around your kids and say that, give them this perception that part of them is horrible, which is, what it is. So that's mistake number 8. 2 more to go. Mistake number 9, avoidance. For those of y'all getting served with documents, big mistake, stop ignoring it. Just because you ignore it does not mean it's going to go away, right? Respond, file your response. If you don't agree with whatever they're requesting, file your response, file your answer, file your objection, whatever the case is, but don't just sit there and ignore it. Because again, if you don't respond, one, that could cause you to be penalized, right? If it's something you're required to respond to. It could also allow your case to move forward in default, which means without your participation. So if you had 30 days to respond and day number 32 hits and you haven't responded, you haven't communicated with the other side, and you just think that it's going to go away, they might go ahead and move forward in default, and then they'll get everything they're asking for. If you don't agree with it, then you need to file your response so that you can participate. So avoidance is a big mistake. Don't do it. If you get something, you need to file your responses. And last but not least is not picking your battles wisely. Obsessing over irrelevant issues. I know that you're upset that the other parent cheated. I know that you're upset that your marriage didn't work out or your relationship didn't work out because they did X, Y, and Z, right? Most of the time, the courts don't care about all of that. They want to know what's best for the kid. How are we going to move forward? What's related to the issues at hand, if we're talking about a general divorce, and how are we going to move this forward? If you're so focused on the issues that are not relevant, you're going to find yourself, one, frustrating the court because they don't want to talk about that stuff. But two, you're not going to be able to move in a way that is to your benefit because you're too busy focusing on things that don't matter, right? So pick your battles wisely. Don't fight about every little thing. Does it really matter if you take your kid to baseball practice on Tuesday? Or does it matter that he gets to practice on Tuesday? You know what I'm saying? Like, does it really matter if the other parent is the one that gets to pick out the outfit for the play? Or can you let them get that opportunity one time since you do it all the time, right? There are so many different things. Does it matter what basketball team your child plays on, or do you just want them to play basketball? Especially if we're talking about a 4-year-old. Who cares what team they play for, right? Picking your battles wisely is going to save you a lot of stress and headache. And people, specifically people who have not done the personal work and are just so angry and frustrated with the other parent, they want to fight over every little thing. And that's going to cost you a lot of time, frustration, stress, and money. And I know y'all like to save money, right? So stop fighting. Like, when you are getting ready to go to war with somebody, I want everybody to just sit back and think to themselves, is this war worthy, right? Or is this something I can compromise on? Because there are some things that are war worthy, right? What school your children go to might be a war worthy issue. What doctors they see might be a war worthy issue. Whether they start mental health services or not, and who their therapist is going to be, that might be war worthy, right? What color of shirt they wear for picture day? Yes, that's been a real issue in some of my cases. Little things like that, right? Like, no, it's not worth it. And it's making everybody more frustrated. And it's frustrating the possibility that you all will be able to ultimately co-parent peacefully and cooperatively for your kids. So those are the 10 mistakes that I have. I'm going to repeat them one more time for everyone because one, I saw someone asked for me to repeat one. So I'm going to go ahead and go through all of them really, really quickly, and then I'm going to answer your questions that you had in the comments. If you have any questions now's the time to drop them. I'll answer all the questions to the best of my ability. Mistake number 1, to avoid. Taking advice from non-lawyer friends, family members, and other people that you know. if they're not a lawyer, specifically a family lawyer, right? You don't need to be taking their advice about your child custody case or your divorce or about what to do when it comes to your legal situation. Number 2 goes hand in hand, hiring a lawyer who's not well versed in family law to handle your family law case. Your personal injury homie is not going to get the job done the way that a family law attorney will. Number 3, not being prepared and using "I'm not a lawyer" as an excuse. If you don't have a lawyer, figure out how to act like one. We talked about where you can find information about the different laws and rules in your state. Handle that, right? If you're going to represent yourself, represent yourself. I got a video on that dives deeper into it on my YouTube channel, youtube.com/Merissa V Grayson. I think that's it. All right. Number 4, not following your custody orders. Bottom line, absent a true emergency, follow your court orders. If you don't, be prepared to have to deal with the consequences that come along with that. Number 5, sending angry or emotional text, emails, or social media posts. If you're frustrated, if you're angry, if you feel like cursing them out, which is probably like all the time, take a moment, sit back. Wait a minute. You ain't got to send that message right now, right? Like, you don't have to send it when you're in the heat of the moment. I like to follow a 3-hour rule. If I'm annoyed, if I'm mad, if I'm angry, I like to wait 3 hours, if possible, to see if I'm still going to be bothered. If I'm not, I'll let it go. If I am, I might address it, but now I've had time to process it and I can express it in a way that's not going to get me in trouble, for one, right? And will hopefully get you closer to a resolution. Number 6, not keeping a record of all communication and contact. Make sure you're documenting everything related to your co-parenting relationship with your other parent, as well as your time with your kids, when you talk to your kids, issues that you've had, so that you can accurately depict that and explain that to the court without having to guess and scramble at the last minute. Number 7, signing bad agreements without question. Before you sign an agreement, you should consult with a lawyer. Any agreement ever in life, right? You need to be talking to a lawyer before you sign stuff. We be out here just signing whatever just because, not realizing what it is, right? But before you agree to stuff, especially if it's not something that you're 100% certain about, what it means, what it looks like, make sure that you consult with someone, and so that you can understand exactly what it is that you're doing. Number 8, disparaging the other parent. Don't do it. Don't do it in front of your kids. Don't do it within their hearing distance. And I might have forgot to say, don't allow other people to do it either, right? So what I don't want to hear is, well, I didn't say anything about his daddy, but my sister, that was her. She was saying it. She's the one that called him a deadbeat. She should not be able to do that in front of your children. That is unacceptable, and you need to not. So make sure that you and everybody around you knows that when my kid is around, his or her interests come first. You cannot disparage their other parent. I don't care how raggedy they are and whether I feel the same or not. Let it go. Number 9, avoidance. If you get some documents, if you get a child support paper in the mail, you ignoring it doesn't mean they're not going to dip into your bank account. It doesn't mean that they're not going to find a way to put a lien on your tax return. It doesn't mean that they won't find a way to put a lien on your property, or next thing you know, you wake up and your car is gone. Don't get it twisted. Child support services in particular is very, very adamant about collecting money. So if you got some orders, if you got some kind of legal something going on, and this is any kind of legal thing, right? Not just family law stuff, but any kind of legal issue, do not avoid it. Make sure you handle it. And number 10, not picking your battles wisely. Figure out whether it's war worthy or whether it's something that you can or should let go. All right, so I'm going to pop some questions up here for those of you who had some. So give me 1 second. Instagram, you're on a completely different screen. So let me do my Instagram questions first, because I only have 3. Let me see. What if the child doesn't want to see or talk to the other parent, What if the father does not attend any family therapy session and has not seen them in a couple of years? And should I let my kids go for the summer when he finally wants them? Ooh, that's layered, girl. Layered. So bear with me here. All right, I'm going to take them one by one and I'm going to give you a couple of nuggets, right? And this probably will apply to a lot of people because everybody knows somebody who said their kids don't want to see the other parent, right? So number one, if the child does not want to see or talk to the other parent, you as the parent, the responsible parent, have to know and examine what those reasons are that the children don't want to have that relationship with the other parent. Are you a part of the problem? I'm speaking generally, not specifically to you. Are you a part of the problem? That's something you need to think about. Have you said something that would make them feel that way, or is it solely based on their interaction with the other parent? Secondly, the second question was, what if the father does not attend any family therapy session? That goes to my answer that's related to the first part, right? So if your kids have an issue with either parent, and specifically if you guys ain't getting along, I know I'm going off topic for a second, but if you and the other parent hate each other and y'all are always fighting, your kids need to be in therapy. And that's the sad reality, right? Your children, if you're subjecting them, you and the other parent, or if the other parent is causing a lot of tension, frustration, if you guys aren't on the same page, and if your kids know it in particular, chances are they are greatly impacted by your lack of harmony, right? Therapy ain't never hurt nobody. So that's one way that you can get to the root of the problem of why your kids are saying they don't want to be involved with or talk to the other parent. Your children deserve to have that outlet, be able to seek advice from a professional that can guide them, and hopefully they can kind of break down some of those issues and help them figure out the best way to do that. So my best suggestion that I usually give people, and I didn't give a disclaimer, none of this is legal advice. I'm just dropping some gems for you guys, right? I cannot give you legal advice unless you're my client. I'm just answering your general question. Y'all know they made me do that, right? So anyways, when it comes to your kids and their relationship with the other parent, if there's some tension there, if you guys are having issues, or even if you see that your children are impacted generally by the relationship with the other parent or you and the other parent, I would suggest that why don't you just request or try to agree with the other parent that they go to therapy, right? That the kid go to therapy. And if there's an issue with the parent in particular, you can request that the parents also participate in therapy. And for those of you who have not had, a relationship with your kids, or if your relationship is a little strained, or if the other parent has interfered, whatever the issue is, therapy is usually a stepping stone to get you back to where you need to be, because there's a neutral party involved that can kind of work through some of those issues. So I always tell people, I recommend request to the other parent, but if they won't agree, ask the court to make an order that your kids can go to therapy. That way, you're not the one that's making the decision about whether your kids are going to go with their other parent or not. Should you let your kids go for the summer when he finally wants them? You gotta, if I follow your court orders, right? If there's a court order, follow your court orders. But otherwise, you got to make that decision on your own or with the other parent, or try to reach an agreement about the best way, that you can make whatever kind of visitation happen in a way that's comfortable for the children and the other parent. Always try to do what's best for your kids, and you know what that is. And you deeply know what that is, right? Based on what you truly know about your kids and the other parent. Most of y'all got kids with people that you might not like, but they're a decent human being, and you know that they are a good parent, or at least a decent parent, because a lot of us have different parenting styles and things of that nature, right? You know that a lot of us know the other parent may not cook dinner the way that you do, right? But they still gonna make sure your kids eat. They might not put them to bed at the right bedtime like you do, but you know that your kids are going to get some rest, right? They might not participate in every little thing related to school and education, but if you tell them, they'll get the homework done and the projects done and whatever, right? So you gotta do what's best for your kids, even if you don't like them. So yeah, I hope that answered that question. Okay, so my next question is, let me see. I'll pop this one up. I was told it is bad to go to court every year. Is that correct? I've been trying to get full custody for 10 years. They live with me for 2 years fully now. I don't like going to court unnecessarily, and I tell my clients not to go to court unnecessarily, but there are some situations where you have to go to court every year, unfortunately, specifically really high conflict ones. If you're in that type of situation, I like to say, again, I'm going to say this probably a million more times, therapy helps, whether it be co-parenting, counseling, or courses that you and the other parent have to take to learn how to work together, whether it be blended family coaching or therapy so that you can all figure out how to communicate effectively with one another, or whether it's just therapy for your children or therapy for one of the parents, you or the other parent. Yeah, so going to court every year is going to depend on the circumstances, but if there's something going on every single year, then obviously you'll have to go to court. In this question, Jackie, you specifically mentioned that you've been trying to get full custody for 10 years, but they live with you fully. So I guess my confusion comes in, if they live with you fully, then you might not need full custody. If we're talking about the legal right to make decisions, you can request that you get the final decision-making authority. And I know that, oh, this is another thing I'll touch on. Most courts are going to give you guys joint legal custody, right? You have to share in the decision-making. You have to discuss specific decisions related to the health, education, and welfare of your kids with the other parent and reach an agreement. And if not, then the court will make the decision for you, right? Unless you have the primary authority. If you're in one of those states and both of you are required to share in those decisions, but you found that it's become really, really difficult to make those decisions because the other parent doesn't respond or just won't cooperate ever without good reason, then you might be able to ask the court for final decision-making authority, or what is known as tie-breaking authority, to help you guys avoid having to go back to court every single year over every single issue, right? So, yeah, you have to think about whether you really need full custody. People often think that they need full custody, they need primary custody, they need sole custody, not really understanding what those terms mean. So you have to look at what you're struggling with, and is it really a struggle, or is it just the terminology? And don't get caught up in the terminology. If you're able to make decisions for your kids and they're living with you consistently, you might not need the full custody that you think that you need. You might need something else. So, all right. What is the process for filing for 50-50 custody or visitation? In every single state, they're going to require you to show that the decision that you're asking the court to make is in the best interest of your children or your child. You have to file either a motion or a request, or it might be called something else in your state, right? So you would probably just look up family laws or child custody laws in your state, whatever that is, and figure out what it's called. A lot of courts also have self-help centers that will help you figure out which paperwork you need to fill out. They sometimes have people that assist you. Some courts have online programs where you can fill out your forms online by basing, they base the way the forms are filled out on the questions that they ask and you answer them. So whatever it's called, you basically have to file that document, whether it's a request or a motion, but then the ultimate thing you'll need to do is show that whatever you're asking for is best for your kid. And only you would know why it would be best. So for example, if you're asking for 50-50 custody because you just want more time, why does the court need to give you more time? Specifically, what do you offer? What is the reason, other than I want to be able to have my kids 50% of the time? What is the reason that the court should grant that? And that's something, again, that you might want to do a consultation with an attorney on, to strategize specifically based on your state or your county, so that you'll know what would be a good reason for the court to grant that request. All right, moving on. What if your child doesn't want to do FaceTime? I think that when it comes to FaceTime orders, I think that it's going to be really important to think about the interaction that the child has with the other parent. If your child, the age of your child, little kids, when it comes to phone and FaceTime, little kids don't like to talk, right? So one, if you're the parent that gets the calls and you're calling to talk to your 3 or 4-year-old, understand your child is not going to want to sit down more than likely and talk to you for 30 minutes. 2 and 3 and 4-year olds, shoot, even my 17-year-old, we talk on the phone real quick, right? But do he want to sit on the phone with me for an hour? Probably not. Most of the time, kids want to be kids and do their thing. So do your quick little check-in, facilitate the call. If the other parent wants the call, specifically it's a situation where, the other parent doesn't see the kid a lot, facilitate the call. Be the parent that's cooperative and is trying to do things to make sure that the other parent has the relationship with the kid. Also, another point, if you're the parent with primary custody, courts look at which parent is more likely to facilitate the other parent's relationship. And a lot of people miss the mark on this. I'll do another live on this later. But basically, if you're the parent that's making things difficult for the other parent, you might be the parent that ends up with no custody or minimal custody, because the court has to be able to trust that you're not going to be the parent that's going to interfere with the relationship, absent, of course, a justifiable reason, which we talked about what justifiable reasons are. So if your kids got to do things they don't want to do, right? So if your kid says, well, I don't want to call my dad, or I don't want to call my mom, or you know what? You're going to call your mom. It's time to call your mom. 5 minutes, you got to talk to your mom. That's what it is. I don't want to hear any mouth about it. I don't want to hear a pout, or that PlayStation is gone, or this game is gone, or whatever, if that's what the order says, or if, you need to make sure that that parent has that ongoing communication with the kid. That's the benefit of having custody of a kid, right? You facilitate the relationship, you keep the custody. All right. Next question. I have a few more. If you guys drop your question. Oh, Jesus, I have a lot of them. Okay. What do you do if the father is in North Carolina and the mother's in New York City? The child was taken without me being notified. One, if you know where your kid is, file your custody. You can file a custody action immediately based on the jurisdiction rules in your state. I don't know North Carolina and New York City's jurisdiction rules, so that's going to be step one. You need to find out which state would have jurisdiction over your child based on how long your child has been gone. So, for example, in California, if a child has been here for 6 months, then you can file for custody here, right? If your child is taken to another state, but they were living here for 6 months prior to that, and you file pretty quickly, you can still file in California. If they've been gone for 3 months, the other state might be able to take jurisdiction because they allowed you to have your kid there after 30 days. So you need to know what the jurisdiction rule is related to child custody in that particular state. So to find that out, you can look up the Uniform Child Custody Enforcement and Jurisdiction Act. That's UCCJEA laws. That is the law that is universal, and it basically applies to the states in the United States in particular, but even in some countries. And basically there's just this rule about how cases are going to be governed, specifically to prevent like kidnapping and things like that. So that will be the place that you start. Once you know what court to file in, you file a request for custody and visitation orders if there aren't any orders already in place. And then you obviously will just have to go from there based on whatever your circumstances are. If you don't know where your kids are, if someone takes your kid out of the state without your permission, out of the country, most states have some kind of unit that will assist with locating your kids, right? So, for example, in California, is the district attorney's office. If I have a kid who's gone missing, I have to then file a motion with the court, ask them to have the district attorney's office assist me with locating the kid, going to get the kid, bring the kid back, and then holding the hearing. Every state has some kind of unit. Look up child abduction units in whatever state we're talking about or in your state, and hopefully that will get you in a place to where you can find your child. That's just if you don't know where your child is. What is the upfront fees in general to start a custody visitation or child support order? If you're talking about attorney fees, it's going to vary from attorney to attorney. You have some attorneys that charge thousands. You have some that charge by the hour. You have some that charge flat fees like I do. And then you have some that do unbundled services. So they'll just do some limited services for you based on your budget. You probably can find an attorney in your budget somewhere. If not, there are legal aid clinics in pretty much every state. I've found some. There are, like I mentioned before, there's self-help centers at in every state somewhere, whether it be at the courthouse, through the court, or through some kind of foundation. And when it comes to filing fees, the fees can range. They're usually a few $100. But if you don't, based on your income, some states or counties will also grant a fee waiver if you are not able to afford your filing fees. So I don't want you guys to let money be the reason that you don't fight for your kids or that you don't handle your business, right? There's a way. If you have to do it on your own, do it yourself. I would rather you go to court by yourself and fight for your kid than say, I couldn't afford an attorney, so I just didn't, which is a thing that a lot of people do. I understand the intimidation, but your children deserve and need for you to do more, right? It's going to be difficult if you're representing yourself, but it's not as difficult as just giving up and not doing anything. So don't let the money be the reason. If you don't have the money, then find a way to do what you got to do to represent yourself. If that's your last straw, you know. Okay. People are crazy. The law should be simple. Yeah, I know. It is what it is. The law is what it is. I don't love it, but it is what it is. Now, I see a lot of YouTube comments coming in. Y'all on my YouTube channel, y'all be wilding out. And this is why people don't post videos, because y'all be wilding out. And I'll be having to block y'all. So let me read the questions before I throw them up here, because y'all ain't got no home training. Let me see. Okay, I'll answer this question. It looks like it's a two-part question. I have a motion for enforcement coming up. Ever since I gave her notice, my son barely answers my texts and doesn't want to speak on the phone very long. Do you think it would be parental alienation in the eyes of the judge? Possibly. Possibly. When it comes to parental alienation, that's a very, very complex area of law. It is very complicated and it is very, very real. Whether we're talking about physical alienation, where the kids are just being physically withheld from the other parent, or whether we're talking about the deeply rooted alienation, where the children are psychologically being trained to not want to have a relationship with their parent, right? So there are two different things, both very, very real. It's going to depend on the circumstances. Interference with child custody is definitely a problem, and it's definitely something that you can bring to the court's attention. That's another reason why I tell you to keep records of everything, because if you can show a pattern of behavior that, specifically if you're the one that's always trying to cooperate and the other parent is always trying to interfere, then you're going to place yourself in a better position to ultimately get orders or changes to your orders that benefit your child and you. Okay. How do evidentiary hearings work when changing custody? So if you already have a judgment or final orders in your child custody case, oftentimes the standard to prove to the court, remember I talked before about the standard being what's in the best interest of the child. Once you have final orders, a lot of states will require you to now show, instead of showing what's in the best interest of the child, that's still always going to be a piece, but they're going to add a layer. And they're going to tell you, now I also need you to tell me what are the substantial changes in circumstances that justify us changing the order. This doesn't apply to temporary orders. Typically, it will apply to once you have your final orders or your final judgment. So, for example, if the other parent moved across the country and now the visitation schedule that you have doesn't work, that's a substantial change in circumstances that may justify modification of your custody orders, right? If your kid was 5 years old when the custody orders were issued and now they're going to middle school, that might be a substantial change in circumstances. If your kid is now claiming that they're being abused or now complaining and saying they want to come and live with you or the other parent after a certain period of time, your child's new statements might be determined as a substantial change in circumstances. So you have to be able to show, again, that it's best for your kid and or there's been a substantial change in circumstances to ask the court to change the orders. And then from there, in regards to an evidentiary hearing, for those of you that don't know, that is a hearing where you show up and you have witnesses testify. And that is when you basically will present your evidence, your exhibits, any proof, videos, photos, text messages, police reports, all of that stuff. That's the time that you would present that stuff. Evidentiary hearings are when you put your evidence on. Most of you, if you've been through family court before, you may not have ever been through an evidentiary hearing yet, specifically if you didn't do a trial or you're still in the early stages of your case. So usually one of the first custody or visitation hearings is usually somewhere, depending on your state or county, it's somewhere between 20 minutes and I'll just say 45 minutes, right? And the judge has already read your paperwork. They've read the other parent's paperwork, and then they make a decision after they've asked you guys clarifying questions, and they might even allow you to make a little bit of argument. But for the most part, they make decisions pretty quickly for those initial hearings. An evidentiary hearing is much different. It looks like almost like a trial that you see on TV. Put the witnesses on the witness stand, you ask them questions, the other party gets to cross-examine them, you get to redirect, and it kind of goes back and forth like that. There's an opening statement, a closing statement, similar to a trial. That's the difference between an evidentiary hearing and a normal hearing or a standard hearing, temporary hearing, whatever you want to call it. So, okay, so I have 2 more questions on Instagram. I'm going to see if I can answer those. Regarding FaceTime, what do you do if your kids said they don't want me to force them to do FaceTime? Listen, it's going to depend on the age of your kids. It's going to depend on, your kids better than anybody, right? If your kid is just being a rebellious kid or if there's a legitimate reason why they don't want to do whatever it is that they don't want to do. If we're talking about them talking to you or the other parent, again, that therapy piece will be important to help facilitate that communication with the child who is resistant. If we're talking about a visit, right, since we're on the subject of resisting children, when we're talking about a visit, a lot of people say, well, my 12-year-old, my 13-year-old, my 14-year-old doesn't want to go with the other parent. They don't want to go. The orders say they have to go. They technically have to go, but you can't physically force your kids to do anything. You can't, and I know, corporal punishment was a thing back in my day, back in the day. Some of, it still exists in a lot of homes right now. Oh, another conversation for another day. But these days, right, you physically moving your kid anywhere might be a problem with the law, right? So you can't physically make your kids do anything. But that said, it's important for you to also be a parent, right? And you have to remember that, put yourself in the other parent's shoes. If your kids were at the other parent's house saying, I don't want to talk to my mom or my dad, how are you going to feel if the other parent just says, oh, well, you don't have to talk to them. And then they don't have to talk to you, right? So you have to, just like they don't want to do their homework, they don't want to do their chores, they don't want to go with you to the grocery store, they don't want to do whatever it is that they're supposed to do that they might not want to do because kids don't want to do stuff. What would be your remedy for those types of things, right? Because to a certain extent, you have to be able to show that you have parental control over your kids, because if you can't, if your kids don't listen to you, why do you have custody to begin with, is what they're going to ask, right? So there has to be a balance. And I'm not going to say if your child has been abused, you force them to talk to their abuser. That's a whole nother story. But if we're just talking about a kid who don't feel like talking, some days, okay, you don't want to talk today, send a text or call and say, hey, can we skip today? You know, teach your kids the importance of communicating, effective communication, respectful communication, right? Get them the therapy if they need it, and step into the parental role. And remember, you can always somehow end up in the opposite situation where you're the one that wants the other parent to do something to make sure that your relationship with your kids are good. You know, your kids might be good with you right now, but go ahead and put them on punishment a little bit longer than they wanted to be. Next thing you know, oh, I want to go live with my dad, or I want to go live with my mom. And the tables turn, and you've been allowing them to do whatever they want up until this point. Now you're going to be in that situation. So just always, again, everything is based on what's best for your kids. And when we're talking about what's best for your kids, we're talking about what's best for their character, what's best for their habits that they're building going into life, adulthood, you know, going into teenage life, becoming young adults. Like, what are you teaching them at all times? If you're teaching them anytime you say, I don't want to X, Y, and Z, you might be putting yourself and your kids in a situation that's going to kind of compromise what you will need them to do or what they need to be able to do as an adult. Because life doesn't really work like that, where you just say, oh, I don't want to go to school today, and you don't have to go. All right, I think that's all the questions. Again, for those of you who are new around here, I'm Merissa V. Grayson, child custody family law attorney. I'm a business and entertainment attorney, so I talk about all things life, law, family, and business. I have a regular page. For those of you who are on Instagram, you're on my Family Court Academy page. I'm also at Merissa V. Grayson, MERISSAV Grayson, GRAYSON, on my other Instagram page if you're interested in any topics that aren't related to family law. For those of you who have been hanging and rocking with me on YouTube forever, I think I'm back, and I'll be posting videos regularly. Thank you all for tuning into this live. Please make sure you share. I'll leave the replay up probably till tomorrow, and I will announce later on this week what day I'll be going live next week. If you have any topics you want me to touch on, feel free to shoot me a DM, comment below, and otherwise, thank you all for being here. I hope you found this helpful. If you have, drop some emojis or something in the comment section, and I will see you all next time.